My name is Michele Ballagh. I'm a lawyer and trademark agent here in Hamilton. I practice out of law firm Ballagh and Edward, and we're located in the McMaster Innovation Park. Today I'm going to be talking about trademarks for entrepreneurs, specifically selecting a strong trademark for your business. In legal terms, a trademark is any exclusive mark or sign by which you identify your product, service, or business in the marketplace. If the mark is exclusive to your business in its relevant market, you should enjoy a monopoly in the mark or the sign. Typically, most people are familiar with trademarks that feature words, graphics, or colors, or a combination of these things. However, there are other types of marks that can be eligible for legal protection that people should consider in their marketing plans. These include unique packaging, sounds or melodies, and even scents or tastes can be registered as trademarks or protected as trademarks. Canada will register national monopolies in most of these types of marks, with right now the exception of a few of the sensory marks like sense and taste. But by the end of 2015, Canada should be acceding to and implementing a few international treaties that will require it to register all these various types of trademarks. From a legal perspective, the strongest trademarks are those which are either entirely invented terms or known words or phrases that have a suggestive quality. For instance, Xerox and Kodak had no known meaning before they were adopted as trademarks, so those are invented terms. On the other hand, Nike was the Greek goddess for victory, and that term is therefore considered suggestive when you use it for athletic clothing or footwear. In selecting a new trademark, there are 3 questions that you should consider before you start using the mark. The first question is whether the proposed mark is functional or descriptive of the product, service, or your business, or the geographic location of your business. If so, you may not be able to exercise an effective monopoly over the mark. For obvious reasons, you can't prevent your competitors from using common terms for your industry or describing their business as located in the same city as yours. For similar reasons, you cannot monopolize the purely functional features of a product or its packaging. The second question is whether the proposed mark is a name or a surname. If so, you may need written consent from the person whose name you're using, or evidence that the name has become exclusively associated with your business in order to enforce a monopoly in it. In addition, you may not be able to effectively prevent others with a similar surname from using it to promote their business. The third question is whether the proposed mark is confusing with the trademark of another business that operates in the same or an overlapping market. If so, you may be vulnerable to an infringement claim. Trademarks are considered confusing if the use of both marks would likely lead consumers to believe that the associated goods and services are offered by the same party. It is important to consider that confusion may be found even where the marks appear different but have a very similar sound or meaning. For instance, words like hurricane and typhoon may be considered confusing on a legal basis because they have a similar meaning. On the other hand, identical marks may be adopted as trademarks for different businesses that operate in entirely distinct markets. For instance, Apple is used as a trademark in Canada for both computer equipment and motor vehicle glass. Once you've identified a few marks that interest you, you should ask an experienced trademark lawyer or agent to conduct some searches to ensure that they are available for adoption in the countries or countries where you propose to use them. Although trademarks are familiar to each of us as a consumer, business owners do need to consider trademarks from the other side. A trademark is a form of property. A prudent business owner would not buy land or build a structure on it without first ensuring they know the boundaries of the available property. The same is true for trademarks.